So whether we're talking about engagement with the Constitution's text, faithfulness to history, compatibility with basic constitutional structure, in which limits on power is a driving principle, or respect for settled understandings of not just courts, but presidents, Congress, and the public throughout our history, the Chief Justice's opinion announcing a sweeping new immunity for ex-presidents fails badly. I'm going to touch briefly on each of these. So first, as to text. It is not just that there is no immunity for presidents or ex-presidents in the Constitution, although I do think that's maybe relevant, but the textual clues that do exist cut directly against the court's conclusion that ex-presidents enjoy sweeping immunity. We know the president can be impeached. The president is the first official listed in the Constitution as subject to impeachment. The Constitution even singles out presidential impeachments as subject to special treatment in that the Chief Justice presides over the trial if it's the president being impeached. The impeachment judgment clause limits the punishment that impeachment can carry to removal and disqualification from future office. But it also adds that impeached individuals are, quote, liable and subject to indictment, trial, judgment, and punishment according to law. That is, an express provision making clear that impeachment does not preclude criminal prosecution. The natural way to read those clauses together is that the president is subject to criminal prosecution, or at least the ex-president is. I suppose we can debate presidents. But if that wasn't enough, consider that Article 1 of the Constitution expressly grants members of Congress immunity for their speech or debate. The lack of any comparable provision granting such immunity to presidents and ex-presidents under ordinary rules of constitutional interpretation would seem to suggest the Constitution should not be read to grant such immunity. Next, consider what founding era history tells us. Here I'm going to be brief. There's an amicus brief filed in the case by a group of eminent historians, and they put it better than I could, so I'm going to quote them here. Sometimes, they say, history speaks ambiguously, but here it speaks with surpassing clarity. While the founders had a range of ideas about the scope of executive power, none of those ideas included conferring immunity on the president in the circumstances at issue here. The argument to the contrary is not historically credible. Let me give just a couple of examples of relevant statements from key founders. Alexander Hamilton wrote in Federalist 69 that former presidents would be, quote, liable to prosecution and punishment in the ordinary course of the law. He emphasized that while in Great Britain the king was sacred and inviolable, the president, by contrast, would be amenable to personal punishment. James Wilson, perhaps the most important founding-era thinker on the presidency, wrote that federal officers who commit crimes may be tried by their country. If their criminality is established, the law will punish. James Iredell, one of the first Supreme Court justices, explained, quote, if the president commits a crime, he is punishable by the laws of this country. There's nothing remotely comparable in the historical record pointing in the opposite direction. John warned me about the wind. I'm glad I have these rocks up here. Next, constitutional structure. So the idea of limitation, branches checking one another to avoid excessive accumulations of power, is absolutely foundational. And here I'm going to quote Madison's Federalist 51, which is perhaps the most famous meditation on the separation of powers. And there Madison explains that security against a gradual concentration of the several powers in the same department, that is a branch of government, consists in giving those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. Ambition must be made to counteract ambition. This is the famous language. The interest of the man must be connected with the constitutional rights of the place. It may be a reflection on human nature that such devices should be necessary to control the abuses of government. What is government itself but the greatest of all reflections of human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. So at odds with all of that, this decision hands presidents and ex-presidents an enormous new shield and also disables both Congress and the courts from checking presidents and ex-presidents. Okay, then there are the precedents, and that's both court and non-court precedent. So let me start with the court's precedents. So almost exactly 50 years ago, in July of 1974, the Supreme Court rejected another extravagant claim of presidential immunity, Richard Nixon's effort to have the court excuse him from producing White House tapes in conjunction with the special prosecutor's investigation of the Watergate break-in and also cover-up. Just 4 years ago in Trump versus Vance, and that's confusing. It is not running mate Vance, but then Manhattan DA Vance, who was investigating Donald Trump's finances, among other things, and Trump resisted a subpoena from a Manhattan grand jury arguing immunity. And in that decision, in another opinion by John Roberts, the court rejected the argument that Trump should be exempt from this subpoena, quoted John Marshall, noting that while, quote, a king is born to power and can do no wrong, the president is of the people and subject to law. Even Justice Alito, who would have shielded then sitting President Trump from having to cooperate with this investigation, emphasized that he was talking only about sitting presidents. Alito wrote, this is just 4 years ago, quote, the law applies equally to all persons, including a person who happens for a period of time to occupy the presidency, claiming only that the nature of the office demands, in some instances, that the application of laws be adjusted at least until the person's term in office ends. So even though those cases involving the president's involvement in criminal process cut sharply and I think decisively against immunity, the court essentially disregarded them. Instead, it purported to rely on two cases, Youngstown, which I will talk about, and the 1982 decision, Nixon versus Fitzgerald, in which the court held that ex-presidents were immune from civil damages suits, that is, from being sued for money by people unhappy with presidential policy. So the court here essentially extended Fitzgerald to announce a new immunity from criminal process, despite the many important differences between civil and criminal processes, and even though Fitzgerald is replete with statements about those differences. Okay, non-judicial precedent. Briefly, there is considerable evidence that previous presidents have understood that they could be prosecuted after leaving office. There's an anecdote in Robert Jackson's book, That Man, which was published after Professor Barrett completed the manuscript that Jackson had begun. And during the early part of FDR's presidential administration, this is just a brief, sort of a detour, but I think an interesting one. The only airport was essentially a pasture that intersected a highway that required closing roads when a plane was going to land or take off. And the president decided the country needed something more than a cow pasture as a national airport, and he wanted to reallocate some funds in order to build one, like a real airport. And he tasked Jackson, who was then the Solicitor General, with figuring out how to free up some funds from other sources for this proposed airport. Jackson found a way to do it. He told FDR how he proposed to move the funds, and FDR asked Jackson whether he was likely to go to jail because of it. Jackson replied that he was willing to go to jail with him if that was any comfort. It's a passing exchange, and I don't want to read too much into it, but I do think it's revealing in that no one thought the president was, by dint of office, categorically exempt from legal exposure. There are other important examples. Richard Nixon never faced any criminal charges for his involvement in Watergate because, following his resignation, President Ford granted him a full, free, and absolute pardon. And the text of Ford's pardon makes clear that but for the pardon, Nixon might have faced criminal prosecution for his conduct while president. Ford wrote in his proclamation that, quote, Richard Nixon has become liable to possible indictment and trial for offenses against the United States, and explained that he was granting the pardon in order to avoid exposing to further punishment and degradation a man who has already paid the unprecedented penalty of relinquishing the highest elective office of the United States. The day before Bill Clinton left office, he reached a deal with Special Prosecutor Robert Ray to pay a $25,000 fine and to agree to a suspension of his law license to avoid criminal prosecution arising out of his testimony regarding Monica Lewinsky. And just 3 years ago, when Mitch McConnell voted to acquit Donald Trump following Trump's impeachment trial for incitement of insurrection, McConnell explained that, quote, we have a criminal justice system in this country, we have civil litigation, and former presidents are not immune from being held accountable by either one. So that's an overview of what the traditional modes and sources of constitutional reasoning would produce on this question of immunity for ex-presidents. But the court in Trump versus United States rejects all of that in favor of a mode of reasoning that was nakedly consequentialist and pragmatic. The court worried about what it would do, like what it would mean for the court not to protect ex-presidents from liability for the crimes they commit in office. The court warned that refusing immunity would result in a chief executive, quote, unable to boldly and fearlessly carry out his duties. The court also reasoned that, quote, the hesitation to execute the duties of this office fearlessly and fairly that might result when a president is making decisions under a pall of potential prosecution raises unique risks to the effective functioning of government. So these passages tell us what is really driving the court in announcing this immunity: concerns about consequences. And to be clear, I am not opposed to judicial pragmatism. I think courts should consider the consequences of their decisions. I think that is at the core of the exercise of judgment. And since I think it's inevitable, I favor being straightforward about it. But what is so difficult to swallow is this court all of a sudden employing this method. Contrast this reasoning with the court's disdain for reasoning from policy or consequences in other spheres. Guns, say, or the liberty and autonomy interests in deciding whether to continue a pregnancy or to marry the partner of one's choice. In cases involving those sorts of questions, the court, or at least some of its members in the current majority, has posited that it is illegitimate to consider the consequences of adopting one reading of the Constitution versus another. Let me give just a couple of examples. When the court in the 2008 case, Heller versus District of Columbia, for the first time declared that the Second Amendment enshrined within the Constitution an individual right to gun ownership, unconnected to the well-regulated militia that is expressly referenced in the Second Amendment, the court rejected the argument that it should consider the impact of its decision in validating DC's handgun ban. Justice Scalia wrote, quote, "A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them, whether or not future legislatures, or yes, even future judges, think that scope is too broad." Or here's Justice Thomas in the 2022 Bruen case, which built on Heller and made it significantly more difficult to regulate firearms without violating this court's conception of the Second Amendment. Quote, "Reliance on history to inform the meaning of constitutional text is, in our view, more legitimate and more administrable than asking judges to make difficult empirical judgments about the costs and benefits of firearms restrictions." Here's Justice Alito making a similar argument in Dobbs, the 2022 case that overruled Roe versus Wade. Quote, "In interpreting what is meant by the 14th Amendment's reference to liberty, we must guard against the natural human tendency to confuse what that amendment protects with our own ardent views about the liberty Americans should enjoy." Or another passage, "We don't pretend to know how the political system or society will respond to today's decision overruling Roe versus Wade, and even if we could foresee what will happen, we have no authority to let that knowledge influence our decision." I could go on, but you get the gist. The court's current majority has made it a central component of its judicial philosophy to reject and sometimes to disparage reasoning from consequences. But here, when the tools and frameworks the court says should guide it in deciding constitutional cases do not yield the answer it wants to give, it disregards them completely.